Hello, I'm April Jones, and we at Jones Law Firm care about you, your family, and your well-being. That's why we've put together this informative webinar series to answer your questions about life, about the law, about your family. So thank you for joining us, and let's get started. All right, guys, it's 11:30. We will go ahead and get started because we have a lot to cover today. I'm April Jones. I'm with Jones Law Firm PC. I've been an attorney 30 years. We have had Jones Law Firm in Colorado for over 20 years. Today, we are talking about social media and divorce, how your posts can, and I want to say, and will, be used against you. And I have with me today our senior attorney, David Collins. Dave, introduce yourself, and then let's just jump in with some of these questions. We've got some good questions today.
Thanks, April. Yeah, good afternoon, everybody. I'm David Collins, attorney in April's office. Been a lawyer since 2014, specializing in family law, parenting time, child support, maintenance, adoption, and all things family law.
Yes. Okay, David, do you want to just go ahead and start with some of the questions?
Sure. Let me just start with a preface that social media activity is brought into our practice constantly. Both by our clients and by opposing parties. So right out of the gate, we're going to tell you that your activity on social media and your opposing party's activity on social media can and will find their way into your case if something occurring on social media is relevant. The first question we were asked is, I'm in a contentious divorce with friends in common on social media. So me and my ex have friends in common on social media. How should I protect myself? From that question, I'm not entirely sure what risk they're concerned about, but tensions can be pretty high between two people that are divorcing. Many people have friends in common, and they share Facebook friends. And my first caution would be, don't discuss your divorce or parenting or anything else with people on social media in general, and then especially if your spouse can read your posts and maybe use them against you. So I would be cautious what you communicate on social media regarding your divorce and your kids and the other party in particular. You also don't want to disparage the opposing party at all on social media. That can just be used against you later to show that you're really not going to be able to cooperate with them because you have so much animosity towards them. So that's my caution there. I don't know if you want to try the next question, April.
Well, I'll just jump in a little bit on our first question. And one thing that I tell clients is treat your social media communication as if you're like writing it for the judge to see, and then let that help you decide what to say or what not to say. It doesn't always work when I tell clients. I mean, once you experience it, then you're more inclined to write that way. But that's just kind of a tip to help you decide if something is something you should say or if it's something that you should not say. All right, next question. What are some examples of posts being used against a client you've represented or that you used against an opposing counsel? So I had a case once. It was an issue of an ex-boyfriend and whether or not the boyfriend was fit to be around the child. My client said that he was not fit to be around the child. The other person said that he absolutely was. And right there on social media, and we found it during trial, I think, like at lunchtime, there was a post that he was like, I'm so high, I can hardly get off this couch. And the baby was at his house. He posted that he was so high, he didn't think he could get off the couch. So that was very helpful for us. That's a bad thing to post if you are a person anticipating parenting time. It helped make a case, obviously. David.
Yeah, I agree. I have a couple examples. One similar to April's, and I've had this example several times where a parent will post pictures on social media. Usually it's a party or a gathering at the house. And in the background, you can see drug paraphernalia and alcohol. And alcohol is not illegal, but if the other side correlates that it was your parenting time and you have a house full of people with a ton of alcohol and drugs, that could be a real problem. Another way that social media really comes into play is that people tend to distribute and brag about their business interests on social media. And so people will file a sworn financial statement with the court saying they have no job, they have no income, and they don't own a business. And then on social media, they might have a website dedicated to their business, their Pilates company or their ice cream company. And they might tell you that they have 4 jobs on social media. And so it's really can be detrimental to a party to be posting things that they've otherwise denied. And that is pretty common. People denying income, denying job, denying owning a business, but then trying to generate and stimulate the growth of that business that really does exist on social media.
Next one, David.
So my ex is posting pictures with a new partner. It looks like they're living together. Could this affect how much I pay in alimony? The question is maybe. Maintenance will terminate automatically if the other party gets married, but not if they're living with someone. So if you're divorced from somebody and you are paying them maintenance or alimony and they get a girlfriend, doesn't change your payment. If they live with their girlfriend, doesn't change the payment you make. The only thing related to them having a new relationship that would affect maintenance is if they get married. And if they get married, then by statute, your maintenance will terminate. I think April and I would both tell you that we have had plenty of cases where the other party who's getting maintenance just deliberately doesn't get married. So the maintenance payments don't stop. I
Yes.
did have a case 2 weeks ago where maintenance did stop because the other party got married, and he got married 2 years before maintenance was going to end. So he gave up $950 a month or something in maintenance for the next 2 years because he got married, and it automatically stopped maintenance.
And we're referring to non-contractual maintenance, just the maintenance that the judge would order you to pay. And that's a good one. What about when people post about their relationships when they're married? That the problem we get there, it's not that it's illegal or that you're breaching your parental contract, but you can be infuriating the other party if you're trying to reach some sort of agreement. So when you post about your relationships, your new ones, and you think, oh, it's cool, we're separated, it can just really fuel a very messy divorce. Messy divorces can cost a lot of money. So it can cost you a lot of money to post about your new relationship if your current spouse, who you're not divorced yet, takes it personal. Now, if you're both, if nobody takes it personal, if everybody's fine with how your relationships are going, that might not be an issue for you. A lot of what we're saying here today depends on your case and depends on what's an issue for you and for your ex. Everybody is different. It would be like saying, you know how you can have several friends and let's say you have like 5 girlfriends and they all have boyfriends. Their relationships are so different that when you're giving them advice or you're frowning or you're smiling, it's really very dependent on that particular couple. That's how it is for us when people are divorcing. The advice we're giving you needs to be tailored to your situation. Are you in a situation with someone who's jealous? Are you in a situation with someone who really questions your ability to parent and says you drink too much? That same posting about a party that David was talking about, if neither parent has any concerns about drinking and says, oh, they just had a good time, that's what they do at parties, they're great, capable parents, then that post won't matter. So it really depends on your situation, and you have to be sensitive to your situation and wise. And that's really what we emphasize at Jones Law Firm, is being thoughtful and strategic. And we look at every case individually, because even if your cases look similar, you're different people and you have different buttons that can be pushed. Next question, David.
April, I'm going to jump to a question from the chat. And the question is there a time frame when a boyfriend and girlfriend become common law married that would affect spousal support? And the answer is there's no automatic common law marriage in Colorado. So 2 people can live together and never be common law married. Colorado Supreme Court just issued a new case earlier this year that really solidified Colorado's requirements for common law marriage. And the number 1 requirement is that the parties hold themselves out as married. And there's a lot of ways to do that. So there's no one piece of evidence to determine common law marriage, but it certainly requires the parties to believe that they are common law married or behave in a way that married people do. Examples are wearing wedding rings, celebrating anniversaries, having each other on insurance policies as a spouse. I can't emphasize enough that it really is an accumulation of evidence that has a court arrive at common law marriage, but just two people living together is not at all a basis for common law marriage.
Yeah, there was a time in the old cases, because someone lived together, you can imply that they were married, or because they were on the same bank account, you can imply that they were married. The court recognizes that it can't do that anymore. People live together solely to not be married. So that's not an indicator anymore. People buy houses together that aren't married. People put their names on bank accounts. So you can see how it could be less clear. And so when David says cumulative, in the course looking for cumulative, it's a literal, I did this because we're married and we're holding ourselves out to our community as married. So that is what you will need to demonstrate. So with respect to the question about your situation, are you telling people that you're married? Are you telling people that you're not married? So that's what you need to look at. Again, it's specific to you, especially in this common law marriage situation, because you very well could be holding yourself out as married. We need to kind of look at more details to see what it is you're saying or not saying.
So a follow-up question someone posted, if you say you're married on Facebook, does that count? That is one piece of evidence you could use as a proof of common law marriage, but again, just one piece. So the other caveat there is it takes both parties in a common law marriage for a common law marriage to exist. So if one party says, you know what, as far as I'm concerned, we're married, but the other party says we are in no way married, that is not a common law marriage. It has to be a meeting of the minds of both parties. And that new Colorado Supreme Court case really fleshed that out, because one of the cases they had, one party acted like they were married and told everyone they were, and the other party always said, no, we're not married and we never will be. So it wasn't a common law marriage.
Yeah, you have to have a meeting of the minds. But that is a good question. And it's really on point about what happens when you check the box that you're married on Facebook. So think about Facebook. Do people always tell the truth in their profile? Did they intend to tell the truth in their profile? Can you rely that whatever you read in a profile is a true thing? So the answer to all those questions is not really no. You can't swear that. You don't read a Facebook profile assuming that everything is true. So that still goes back to David's cumulative point. That could be we would definitely say, and they put it on Facebook that they're married. So we would definitely use that. Or we would say, and they put it on Facebook that they're single because they don't believe themselves to be married. So it is a factor.
There was another question in the chat about alcohol and marijuana consumption on parenting time. And the answer is, it depends.
What's the question, David? What's the question?
I think it was, I'm just going to look back at it, if they're treated differently. It was, can you talk about the line between alcohol and marijuana use? It's legal, but it can affect parenting time. So first and foremost, I would say, go to any restaurant in Denver this evening, you'll see parents drinking right next to their kids. So drinking on your parenting time itself is not illegal. If either parent has a drug or alcohol issue, the court may be inclined to order that they not consume marijuana, alcohol, or anything else on their parenting time. We get those orders all the time for people that have addiction issues. It can be really difficult with regard to people that don't have addiction issues and proving that they're impaired on their parenting time, especially when the parent who has the concern is not there. So it's a slippery slope. When someone has an alcohol or drug problem, court's very common to tell a party they cannot consume on their parenting time. Marijuana is tricky because if you test someone's blood, you don't really know whether they were high now or high yesterday. So it can be hard to say whether someone was under the influence in the moment with marijuana, whereas alcohol, it's out of your bloodstream in 24 hours. So if you have a high blood alcohol content, it's because you just drank. Whereas regular marijuana users may have a high blood content and may not have smoked in 3 days. So it's a difficult situation.
And the other thing, to use your example even more, David, so you would see parents drinking next to their kids in any restaurant in America. But if you're getting high next to your kid, that's a problem. We've had children tested. We've had their hair tested to babies to see if there's marijuana in their hair. And there has been. So obviously, if a child has the presence of marijuana in their body, it came from their exposures in their space where they're residing or living or spending time, which goes back to parents or people that you're allowing your children to be around, which is still the responsibility of a parent. So they are very different while similar. And back to tie that to our social media issue, you have pictures of yourself drinking here, drinking there, drinking everywhere. I was so drunk last night, I threw up, I could hardly get to the bathroom. I mean, that starts to tell a picture as well. So um, it's they can be they treated end up being treated very similarly, and the court, as David was saying, will put in protections about that. You could have to blow on a breathalyzer before or after your parenting time. You could have to test, um, do a urine test before and after parenting time, and then quarterly submit a hair test when it's a marijuana or drug use type issue. So there are ways that the court uses the assistance of testing to assure that the child is safe during the parent's parenting time.
So another question we were sent before today was, my ex is producing financial statements that look like they can't afford child support, but then on social media, they're taking a Caribbean cruise for 2 weeks. What can I do? And so to modify child support, either party has to be able to tell the court that there would be a 10% change in child support. If there's a 10% change, a party can file to modify child support. That's not that much money. That's on a $500 monthly child support payment. You're saying it would swing $50 in either direction. So if you have reason to believe that someone's income is higher than it is, you may be in a position to file a motion to modify child support. Once you have filed a motion to modify child support, if you have sufficient basis, you'll then get complete financial disclosures and can actually ask for an even more comprehensive set of disclosures to really get to the bottom of what someone's assets are. And if you did that, you'd be able to find out how they paid for the Caribbean cruise. And my caution is, it may not be them. So sometimes our clients are using money, or the other side's using money that they haven't revealed or divulged. But half the time it's because someone else in their family bought them the vacation, their in-laws, their brother-in-law, their new girlfriend. So we do have a lot of situations where our client sends us an email saying, here they are in Mexico drinking beer, living the great life. And then we reach out to opposing counsel, and sometimes opposing counsel, in an effort to keep costs down, avoid litigation, will just show us that their client didn't pay for the travel. Someone else did, so that nobody has to spend 6 months fighting in court and getting attorney's fees built up for something that was made out of nothing. But the overall question is, if someone seems to be living well beyond the means that they have reported to the court, you might be in a position to modify child support and take a much closer look at their current financial statement and current financial situation.
And one thing when you're doing that assessment about whether or not you think the person's living beyond their means, are they putting it all on credit cards? Americans are famous for putting all sorts of things on credit cards and then, quote, living beyond your means. So if that's the case, that wouldn't modify child support, because that's just more debt. In order to modify child support, we need to see more income. Now, one thing that we should point out is that under the statute for child support, in terms of what is income, significant gifts that are ongoing can be considered income. So if you've got this trip, but the person is not just a one-off, $1,000 trip to Mexico, but this is a constant giving of money because there is someone in their life who is rich and giving them money, that's something we can look at for modifying child support as well. Not the easiest thing, because it has to be continuing, and someone can always say, I'm not going to do that anymore. But it is a factor, and I just wanted to point that out, that gifts can be a factor when you're trying to decide income.
So someone asked the question, how can I best protect my privacy and protect myself through my divorce proceeding? My first answer I can't emphasize enough is change all of your passwords, not just to your Facebook page and your other social medias, but your bank passwords, your email password. So many times clients don't know, one, either their soon to be ex or their ex has their passwords, or what's more common is they have a computer you used to share that saved all the passwords and they automatically log them in when you don't know it. So you want to limit anybody's access to the records the accounts you have by making sure that the passwords are changed in that way. And I'll tell you, we have cases where someone comes to us and says, we have your clients' bank statements because they had a joint account and they haven't changed the password, and here they are. So be cautious about access to your stuff. The second answer is be careful what you post. So everything you post can be used against you. April and I have cases where someone says they're not working, and then they post on social media that they operate multiple businesses. We have people that say they're disabled, and then they're on social media water skiing.
And playing tennis.
We have people that say I can't fly because I have a compromised immune system, and then they're in Paris. So social media is a truth agent. It tells everybody what you're doing, when and where and how. So I would say exercise caution in that regard, and also how you portray yourself in your household, and on your parenting time in particular is very important. Or just not putting it out there at all is important. And just because your ex doesn't have complete access to your Facebook account doesn't mean that their friends don't. So your other people who have access to your account, they're friends with you, they can share their content and it's still evidence that's admissible one way or the other.
Yeah, I think maybe it's not quite weekly where we're telling someone to screenshot a post because we don't know when it's going to get taken down. And this is a friend of a friend because our client was unfriended. So the person thinks they can just post freely. And it's still like locking your front door, but just leaving your back door wide open to anybody. And we often say, okay, well, you don't have access to these posts that would really help our case. Who do you know that they know that would have access and that would give you access? And inevitably there's somebody. So your stuff is still wide open. It's almost more dangerous when you think that it's private because you unfriended someone, because then you're not censoring yourself as if you were typing for the court. So again, that takes us back to my point that treat every writing like it's an exhibit that I'm going to be surprised with that court for the judge. Either I'm going to show the judge or somebody else is going to show the judge, and have it meet that standard. And if it doesn't, delete it all until you're through this process, you have your court order, and you're on solid grounds.
Yeah, and one more example I'll give you is, we do have clients who earn their living on OnlyFans or other websites that engage in pornography. And it's not illegal to be a stripper. It's not illegal to have an OnlyFans site. That's not the concern we're raising. I mentioned this earlier, but we've had cases where the photo shoot for OnlyFans occurs on the parents' parenting time and in the presence of the children. That's a problem. So having this sort of business activity is not illegal and may not affect your parenting time. But say if you're filming pornography at your house on your parenting time, that's going to be a problem for the court. So you have to be careful when and how you engage with social media, especially in the presence of your children, if you're engaged in an activity that children really shouldn't be exposed to.
And you also need to be careful about what you're putting out there, period, because collectively it tells a story. And if somebody decides that it's important to them to collect things to tell a story about your life, and it's not a story you want presented to the court, that's what you should be really aware of when you are on social media or in a business that has you put posts of yourself.
Yeah, another example of that really seems kind of innocent is you say you're flat broke and you can't pay child support, but then you have posts of the last 7 tattoos you got in a 3-month period that probably cost $2,000. So, people will show that they're spending money they say they don't have. And it happens on social media all the time. There was another question. What do I do if my ex constantly talks about me and puts me down on social media? That may not be a family law issue. That could be a civil protection order issue if there's enough behavior to be considered harassment. Um, that there's no fine line on whether, how, and when you're being harassed. But if someone is attacking you and disparaging your character, um, you may be in a position to get a civil protection order. On the other hand, in a parenting case, if someone is constantly attacking you and disparaging you, that might rise to the level of an act of domestic violence. It might not, but it might convince a judge you can't make decisions together. If someone is going to constantly attack you, maybe you shouldn't have to share decision making with them because it's offensive to be under the attack constantly, and a judge might think you can't cooperate with someone who's perpetually attacking you.
That is very true. So really be cautious, be careful. There's an automatic injunction that goes into place when you file for divorce or you file for custody that says that you can't harass the other person. And so we could, if you have an action going, we could file under that and tell the court that you are in fact being harassed by the person and ask for court orders for it to stop. So if you have a current case or we file a case, we can file to stop that harassment under the automatic injunction that goes with cases. So that's an option as well.
So someone asked, once my divorce is final, can I post whatever I want? You can post whatever you want now. It's just whether you want it used against you. Our caution about posting whatever you want after your divorce is final is that half of our caseload is post-decree litigation. So unfortunately, contentious parties find their way back into court to keep litigating over parenting time, maintenance, child support. So even if your divorce is over, it's our caution, don't hand people more evidence to use against you should you find yourself back in court. And our biggest advice is, if you divorce somebody, never post about them again. You don't have to. You get a get out of jail free card when you get a divorce. You actually don't have to interact with your ex unless you have kids, but you certainly don't have to talk about them or engage them at all. You get to move on. So it's hard to do, but we encourage it. But our advice is to leave the past behind you and do not spend your social media activity engaged in information about the other side. It doesn't usually serve you very well.
The other thing is for you to realize that custody and child support is modifiable, as David was saying. Anytime there be a 10% increase or decrease, modifiable until the child is 19. And beyond that, if there's some sort of issues with their functionality and disability. But let's just stick with the 19, which is typical. So even though your divorce could be final, your orders that affect your children are completely modifiable. If there's a reason to modify parenting time because the child is endangered because of the drugs, the alcohol, because the person isn't home for their parenting time, they don't use drugs or alcohol, but they're gone all the time and they're saying they're home, and the child can't be home with dad because he's in Italy. So then who's home with dad? Who's home with the baby if dad's in Italy, right? So all the time, always traveling. So whatever it is that can become an issue in your case, if you still have children and you still have support, either alimony that's modifiable or child support that's modifiable or parenting time that's modifiable, nothing changes in terms of our advice on social media. You need to be cautious and careful. The thing that could change is that your relationship with your ex could be such that you guys aren't coming after each other anymore. And then what you do truly becomes irrelevant. But that's case by case. And for some people takes time, and for some people never happens. So that's just something to be aware of. Let's take one more question, David.
Yeah, this is a good question. My ex is posting pictures of living a questionable lifestyle, parties. Not that one. I'm sorry. My ex is posting pictures of nights out without the kids on nights that they have the kids. What can I do with this information? My first answer is both parents can have babysitters. Nobody's expecting parents to be with their kids 100% of the time. we at a minimum have to go to work every day. So if you have a kid under 5, they're in preschool or childcare, and in school we get free childcare from 8 to 3 in the afternoon. But in the evening, it's totally okay to have a babysitter. It is healthy and normal to go out and have a life outside of the home, to have relationships outside the home, and to have a babysitter while you do it. Now, if they're engaged in behavior that puts your kids at risk, that's another thing. But we actually encourage people to live a healthy lifestyle, which includes going out in the evening sometimes, not every night, but and having a babysitter when you do that, which is okay.
Now, to add the other side to that, it also depends on your fact pattern. I'll keep saying that. Do you have a case where the person is getting court ordered parenting time and there's this whole component, because we see this really often, where the person is supposed to be spending time getting to know the child, creating a bond that perhaps had been missing. And instead of creating the bond that's been missing, they are not home. Some parenting time plans are intended to increase over time. There's like a trajectory of getting to know the child, starting to have an overnight, starting to have more overnights, working your way toward, perhaps a 50-50 schedule with a child who's getting older. But the court wants you to demonstrate that you have a relationship, that you know how to care for the child, that you can act in the child's best interest. So for those types of cases, if somebody's on social media and they're not home all the time and they're not with their child, then that answers the court's question. No, you aren't able to make decisions where you're spending time and bonding, and where the other person's been saying the whole time, they don't even want to be with the baby. They don't even want to be with my son. They just want to pay less child support. That can show that. So that's a common enough complaint as well. So that's just something to be aware of. Again, base it on your situation. Let us know if you have questions, because this is so fact dependent. Just give us a call. We're at Denver Divorce Attorneys with an S, denverdivorceattorneys.com. You can email us through the site. We're 303-799-8155, 303-799-8155. Give us a call. We'll sit down, talk to you about your case, and talk about what we can do to help. So we are here. We've been here 20 years. We're going to be here 20 years more. So just give us a call if you need us. Thank you so much for joining us today. We hope this has been helpful. Thank you, David.
Thank you. Take care, everybody.
Bye-bye. Thank you for joining us for this webinar. If you or someone you know would benefit from watching a recording of this webinar or any of our other webinars, they can be found at denverdivorceattorneys.com. Thank you, and keep a lookout for future live webinars, and I hope to see you again.